Arun's profile with you.
Yeah, that is with me, sir. No worries.
So you have to take care of it. Okay, sir?
Yeah, definitely. So I guess, sir, we should start now.
Yes, sir.
Yes, sir, we can start, and we are live on YouTube also.
Okay, great. So good afternoon, everybody. Myself, Himanshu Mohta, Chartered Accountant, basically representing today our GCP Global Chamber of Certified Professional of the Chartered Members. So I request, so today is one of the very, I will say, very interesting topic, which is personal data protection, right? So I am telling you, if I talk about myself, I don't have much idea about it. So I am so curious to know about this today's session. So data protection law in India and its global understanding. For the global understanding, definitely we have the guy with us, Mr. Arun. So he is very dear friend of Mr. Sinha, Sachin Bhai. So he is one of the president of our member. First of all, I request Sachin ji to come up and please grace with some words so that we can start our program now.
Thank you so much. Thank you so much, Mehtaji. First of all, I would like to request Sriram Atalji, our Vice President, to tell something about the Global Chamber of Professionals. Then I'll take the proceeding further.
Thank you, Sachinji. Thank you, Mohtaji, for your nice words. So today we are going to start a very good topic, and that is very favorite topic of our President, Sir Sachin Sinha ji. Global Chamber of Professionals is a big organization of all the professionals in all over India, and it's very active for last 5 years. And we are doing many activities for professionals like updation on budget program, income tax, GST, and all aspects which are relevant for chartered accountants. So friends, today we are going to start our program, and our guest speakers from Mauritius also with us. We are very fortunate that we will hear from all of your team. So now I hand over to Sachin sir for further proceedings.
Thank you so much, Sri Ramji, for introducing the Global Chamber of Professionals and telling something about the GCP. So, friends, today's topic is very interesting. That is personal data protection. Because as you all know that as of now in India, we are not very much aware about this bill. But globally, the law is very stringent. And whenever we interact with the international client, the first question they ask that how you will going to protect my data. So I think being a professional, it is very important to understand the intricacies of this law. And apart from this, I must say that once we understand all the provisions relating to this law, we can guide our client in this regard, and we can add a new vertical in our practice area. And for this, for today's session, we have a company secretary, Kirti Dureja. She will take care of the proceeding with Arun, and at the end, she will also contribute his input from in this regard. So it is important to introduce Kirti Dureja as a first hand. Kirti Dureja is a company secretary, is a practicing company secretary having 7 years of experience, and she is into corporate advisory and finance. She is also guiding the client relating to company law, SEBI law, and statutory enactments. She has the ability to carry the audit functions, defining compliances, dashboard, and reports to communicate all the corporate laws. And she has also completed her law from the Institute of Law and Research, and she is practicing since 2016. She's practicing company secretary. Apart from this, she has a director in a few companies. So not taking much time, I'll request Kirti to take the proceeding, and I'll request Himanshu to please introduce our friend Arun, and then we'll start the proceeding.
Surely, Sachinji. Thank you, Kirtiji, for joining us today. So let me have a quick read of the profile of Mr. Arun. So Arun has more than 10 years of experience in the legal field. Mr. Arun is a Mauritian qualified barrister after graduating from the London School of Economics with an upper second class degree, where he was a scholarship holder. Mr. Arun was called to be a bar at the City Law School and was a recipient of the prestigious bursary from the 1946 fund of the Lincoln's Inn. Wow, where he was called to the bar. He is an established law practitioner heading the KL chamber in the Mauritius. Arun specializes in the corporate matter and the niche in the trust practice and the international structuring, and advises on the corporate matter and the cross-border transaction, investment, and tax practice. He is also known for his appearance in the corporate related criminal matters, including money laundering and financial crimes, as well as the tax evasion. He regularly advises on the international trust structuring and its taxation implication. He is also currently advising on a cross-border merger as well as the large cross-border financing transaction. He regularly talks on the structuring issues and is present on the panel of the international conference as well as webinars. He was awarded the STEP Worldwide Excellence Award in 2020. Congratulations, sir, which recognizes the best and the brightest practitioner worldwide. Wow. Arun, Arun has a special interest in the digital services, data protection, and the big data. He has researched and trained professionals extensively on the matter related to the data protection and has researched the extent to which the data protection law and the GDPR can be used for the taxation purpose to add the certainty to the existing climate of the uncertainty. He regularly speaks at panel, recently conducted a CPD session for ECA and ECA members at a joint ACCA and IFA event. Other area of competence: drafting of the document for digital services, training in digital services, trademark registration protection, some of the business setting up, international structuring, advising the client on setting up and ensuring the compliance with the Mauritius law, and the structuring the asset internationally, international structuring, and the planning and the taxation for digital services and general litigation. Over to you, ma'am, to take it further. And Arunji, I really welcome you again. Before hand over the session to you, I request ma'am to please share a few words and take it further.
Thank you so much, Himanshu. Thank you so much, Sanjeev, for getting this topic.
Yeah, Kirti, you are not audible. Kirti.
Audible? I am like, hello.
Kirti, some audio issue is there, I guess.
Yeah,
Am I
Kirti,
audible?
voice. Yes,
Am I
your
audible?
voice is not clear. I think there's some issue.
Okay. Meanwhile, Kirti, I request you to please check the connection, and
Yeah.
without wasting the time, I request Mr. Arun to please take it further, please, sir.
Thank you very much for the quite detailed presentation. I thought it would be in a more concise form that I would be presented, but in any event, thank you very much for the presentation. Most importantly, today I am present together with my team members who are here. At the same time, we have a presentation that is being done by our chambers and also by our consulting company that advises regularly on data protection and data privacy matters. We are today going to talk about a very important topic, a topic about data privacy and personal data protection. India, in its own right, is quite late when it comes to this presentation. The fact that as we speak, many countries have already implemented personal data protection acts and data protection acts, and for the Europe, it is the General Data Protection Regulation. So today, what we are going to do is we're going to conduct an introduction of the topic and also see how we are surrounded by data and what problems may arise when data is shared, and also the protection that is offered by the relevant legislation. What is very important is to be able to tackle this issue. We need to understand that data is everywhere. Data is, even now, we are sharing a lot of data without even realizing what we do. So today's presentation would be to sensitize people on data protection. First of all, to identify areas of data protection and privacy. We're also here to raise awareness on impacts of data privacy, because many people don't realize what are the impacts of breach of data privacy and other implications of data privacy. Our target today is to be able to ensure that people understand the basics of data protection before we go into more complex topics like blockchain, cryptocurrency, uh, taxation, and various other things that could come across with that, including BEPS, Action 1, Pillar 1, among others. And therefore, we will look at the other implications of data privacy. Most importantly, we have to note that no country operates in a vacuum. Therefore, when the GDPR was enacted in Europe, ultimately it overspilled into countries like Mauritius and other countries that had dealings with European law. Similarly, what we had to do is we had to adapt to that. Mauritius, in fact, the data protection, the general data protection regulation of Europe came in force in May 2018. But more importantly, Mauritius was one step ahead in that regard. And the act came in force in Mauritius in January 2018. That is 4 months before. And it was more or less replicated on that act. However, the Indian part, the Indian bill is still a bill. As you would realize, there was a bill in 2018, which didn't make it through Parliament. And another bill, the Personal Data Protection Bill of 2019, went through Parliament, but it is at committee stage for public consultation. However, more importantly, protection of personal data is a must, be it India, be it Mauritius, be it anywhere else. And this has also been confirmed that data protection is a fundamental right. In today's presentation, we will ensure that you have a basic understanding of what is personal data. And as we go along, we'll show the various safeguards that have been put for the protection of personal data of individuals. And then we'll go deep into the debate to see how you can be protected and what are the problems that arise. And therefore, when the act comes into force, at least everyone knows what is happening. As I mentioned, personal data is shared on a daily basis around the world. Sometimes it is being shared unconsciously. And personal information can be shared while talking, creating an account on social media, and many other things. For example, your location, your IP address, or any such software or any such tool that you use that gives out your location and various other information that identify you constitute personal data. Now, when we go through this list, we see the various instances when we are actually giving out personal data. For example, when you're creating an account, a free account on Facebook, when you're creating a free account on Instagram, what you're giving out your email address that identifies you. You're giving an IP address. You're giving a name. You're giving your date of birth. You're giving your relationship status at times. You're giving your gender. And also you're giving a password. And most probably what you don't realize is when you're giving a password, you also give a reminder of your password, and there is a list of questions that you choose from. And that list, when you go through it, it asks about personal information like what was your first school, and where did you go, and what is your father's middle name, for example. You give out personal data without even realizing. Now, when you go to work, every individual who is economically active has a job, and therefore, when you employ someone to work at your place, for example, it could be a maid, it could be anyone else. What you do is you're registering someone's personal data with you. At the same time, you also have financial information about that person. You give them a salary, you have the bank accounts, you have all these kind of information that directly identifies that person. This constitutes personal data. You have registration for Aadhaar card, which is something that we have in Mauritius, and we call that the national identity card, where we had similar issues that arose in relation to giving out of personal data and insensitive information to the government. Therefore, when you apply for that, you have to give your name, your surname, your date of birth, your address, your biometric details such as iris scan and fingerprints. At home now, what is important when you give out personal data? You have a milkman who you pay, who knows what you consume, how much milk you consume. You also have at home, what you also have is you have a TV channel, you have a cable TV, and therefore you choose which program you're going to watch. Subsequently, for example, if you're watching religious channels, if you're watching politically motivated channels, and all these sensitive information that you're giving, you're actually giving out personal data to the cable TV person. You're ordering food, for example. When you order food from the comfort of your home, especially in this COVID situation, if you're ordering food, the food delivery person, you're actually giving your address, you're actually giving your details, you're giving your credit card details, among others. And when you're enrolling your child at school, you're also giving your child's name, address, date of birth, any medical condition, which can be of very sensitive nature. And for yourself, you're actually giving your date of birth, job title, marital status, and email address. This is to show you that in fact, knowingly or unknowingly, we are giving out a lot of personal data. Now, more importantly, many of you must be using an online shopping platform. How many of you have actually gone onto the website and checked what is the privacy policy of that website? I can count on my fingers. I don't think that I even need to count, because none of you, I'm sure, have gone and had a look at the privacy policy. What happens to your personal data? What happens to the data that you put and the information that you give about your preferences? Most of the times, many people have realized when they look up something on Google, for example, about a place that they want to go, they want to visit Mauritius, for example, they want to go to Switzerland. After a while, you will see adverts on Facebook that actually shows you all the good deals that you are actually going to get once you are in that country, be it Mauritius or Switzerland. Have you asked yourself that question? How did that happen? If you're buying something and that thing does not actually, you haven't bought it, but you still start getting adverts about that particular part of it, and that particular product. More importantly, your personal data has been taken from Facebook or that social media platform and has been given to the businessman or to the business or to Facebook or to anyone else who has bought that kind of data which you consented to giving. So this is something that you need to take care of, and this is something that you need to consider. More importantly, the other data that you're also giving are your IP addresses, your pages viewed, your user behavior pattern, your number of sessions and unique visitors, your browsing activities, browser software operating system. Now, more important than anything else, did you consent to giving that information? Most probably you will come and tell me, no, you haven't given that kind of information, but you're wrong. You have consciously been giving out this information without even realizing that. This is giving precious information to others. How? When you have a look at the privacy policy of a website, when you register on an online platform, whether on the social media networks or on an online shopping platform, we are asked to read the terms and policies of the platform. How many times do we read that? I will not mention names because we are live, but if you have a look at the various privacy policies where you do shopping, you will realize that you're actually giving them consent to give out your personal data under contract. To people who are under contract, they tell you that they don't sell, they don't transfer, they don't sell, they don't transfer, or they don't exchange your data against anything else. But they also tell you that what they really do is under contract, they are allowed to give your personal data for the performance of any service that you might have. Now, two things. Firstly, are we actually consenting to giving that information? Answer is no. And secondly, do we read those terms and conditions and privacy policies? Answer is no again. And therefore, what is happening indirectly while we click cookies accepted, while we click privacy policy, while we purchase, what we're actually doing is we're actually giving consent for that kind of things. And most importantly, this is a scourge in India. I've been victim to that all the time, getting calls from when I was in India, I was on my phone, on my Indian phone number. I was getting incessant calls from anonymous calls. Sir, I've got a loan to sell you. Sir, I've got an insurance to sell you. I've got double glazing. I've got many other things to sell you. So more importantly, we're all getting that all the time. So we need to ask ourselves various questions. Do I know this person? Who gave my number? Where did the person get my number? Important questions. Firstly, check whether you have your number in the public, whether you have your number on a social media handle. Check whether you have your number on a Facebook, Instagram page, or where do you have your number? More important, has there been a breach? As far as I know, there's no directory of any mobile phone numbers. So where would anyone get your phone number except for social media, except for going through Facebook where you put your personal number as a professional, but most probably you've put an office number, not always a professional number. So where have you got where have the people got your number from? You might be asking yourself, I didn't consent to give my personal number to anyone. More importantly, how do they know that the number that you have is an active one? And someone has bought that, someone is using that number, and that number is being used, and they tell you they want to sell something, and most probably they know your name, they know what you do, because they wouldn't be calling people if they didn't know what they were doing. So there's some sort of profiling that goes on. Can you ask them to stop calling you? Chances are no, because when you will tell them to stop calling you, they'll just change numbers and call you again, first thing, or they wouldn't pay heed to you. How do you handle it? Most probably you have been a victim of a cybercrime. For example, what has happened most probably is you have been your system has been hacked. In fact, there are around 1.16 million cases of cyber attacks that were reported in 2020 in India alone, and up to 3 times from 2019, and more than 20 times compared to 2016. This could be a common source of your problem that you're facing. And during cyber attacks, lots of data being shared with the attacker, which can be very dangerous as the attacker may have access to your credit card information and other bank-related information. So are you using a software are you using an updated antivirus? Are you using a software that is anti-hack free? Question is yours. Other thing is my very good example that I use for all presentations when it comes to personal data and data protection. I use that example from India, where you have a Xerox copy shop. Most of the times they have that shop. You barely or rarely see people coming into that shop. Not always are they busy, and all they do is photocopy and sometimes SIM cards, and they top up your SIM cards. If you do the simple maths, you see that it might not be profitable for them to do that. But then it's simple. You bring something to scan or to photocopy. They could either scan it and keep one copy for them, or they could do the first copy and tell you, the copy didn't go too well. They will just scramble it and put it in a paper bin, and you have a copy of your personal data in their hands. For the top-up and SIM card shop, what happens is you have to give your personal details when you're going to buy a SIM card. When you're going to top up, you give your name or anything like that. What they could do is what some do. It's very bad to generalize. Is what some do is they sell that data. For example, if they get 1,000, 500 or 1,000 people with those kind of informations in a month, and they sell it for 50 rupees or 100 rupees per personal data, and which they can sell to various suppliers, you can already count the amount of money that they're already making. Also, do you have a shredder in your office? If you don't have, then the garbage collection company has access to personal data that you wouldn't want to. This is something that all professionals have to make sure that they look at. Your attendance reports. How do you do your attendance? Do you have paper attendance? Anyone coming into your office, anyone coming into your building, especially with COVID, what they call contact tracing. What happens is you're asked to record all your details or your address and everything, and it is done on a book, and that book everyone has access. So that kind of data, if anyone takes a picture of that and put it on the net or put it anywhere, not only are you giving out personal data, you might also be giving sensitive personal data. If one of that person is mentioned as having COVID, for example, COVID-19. Other things other sources of breach are hotel booking rooms. And if you have a system where you record everyone who's who's booked a room with you, you are actually giving out, you're actually putting out sensitive personal data, either on your software or if you have an entry and exit book where people have to sign, anything as such, anyone can take a picture and that would count as a breach. Now, we've gone through the instances of your personal data. This has set the context of why you need a law, because your data is everywhere. It needs protection, and you have to be in control of your personal data. It's not that you shouldn't be controlling it. It's your personal data. Personal data doesn't belong to anyone except for the data subject. Data subject is the person who owns the personal data. And a dead person does not have personal data. Personal data is for a living subject. So the data subject should give his consent, and consent is an important part of data privacy and protection. It is important to note that most of the times people don't realize the importance of consent in processing of personal data. This is exactly what GDPR came to do. A person should have control over his personal data. He should be able to give consent, and he should be able to withdraw consent, and he should be able to characterize the consent that he has given. Data has been processed for legal purposes. Therefore, if ever you are unable to give your consent, or you're not in a position to give your consent, or your personal data is important for the performance of a contract, for example, what is important is to make sure that your data has been given and is being processed for the right purpose. And what also needs to be looked at is the various criteria, like the extent of processing as well as the nature of the processing. So you cannot take on too much data. For example, if someone is ordering pizza through your app, you cannot ask them how much they earn as salary before you give them that pizza. This is unnecessary data, and it offends against the principles of data privacy and protection. Consent has been clearly defined, and under section 11.2 of the Personal Data Protection Bill. It is nearly the same that you would find it is nearly the same that you will find in the various data protection laws, and it's more or less standard. Most importantly, the basic principles are that for consent to be valid, it should be free and complies with the standards under the Indian Contract Act. The data subject should be aware of the purpose, and whatever you're asking should be specific, and it should be clear. The consent should be very clear. It can't be ambiguous, and it should be capable of being withdrawn. Most importantly is the aspect that consent should be capable of being withdrawn. However, it's not always, the consent might not always be needed. For example, sometimes personal data may be processed if such processing is necessary for the performance of any function of the state authorized by law, for the provision of any service or benefit to the data principle from the state, or for the issuance of any certification license or permit for any action or activity of the data principle by the state. More importantly, any law could make provision for the fact that your consent might not be needed for a particular act. For example, if you cannot ask, for example, not to process your data when you're going to court after a criminal offense, this is not done. And for compliance with any order or judgment of any court or tribunal in India. To respond to any medical emergency involving a threat to the life or a severe threat to the health of the data principal or any other individual. For example, if you have if you're met with an accident and you're unable to speak or you're unable to talk, you're not in a position to give any consent. So we cannot expect reasonably to get your consent for treatment. You're not in a position to consent. You're not in a position to give your details. People can just try to open your purse, get your Aadhaar card, or try to see if, go through your mobiles, the hospital, to be able to get proper information. Further, to undertake any measure to provide medical treatment or health services to an individual during an epidemic, outbreak of disease, and or any other threat to public health. For example, if you have COVID, for example, they can when you are facing a serious issue, they could try to dig into your medical history, get your information, and process that information, which was an information which would otherwise constitute uh, sensitive personal data, which they will process, or to undertake any measure to ensure safety of and provide assistance to an individual during any disaster or any breakdown of public order. So, for example, they could process if there is a riot along communal lines. They could take measures to ensure that for your safety, you will have to. They could process your appartenance to any particular religious group to be able to help you out. These are the grounds of processing of personal data other than through consent. Now, what we have to do is we have to look at the protections that are offered in cases of breach. As already mentioned, there are several occasions when the data principal feels that his or her personal data has been infringed. So what do you do? Your protection is offered in both the Information Technology Act and the Personal Data Protection Bill. Let's go into the Information Technology Act. If you have a look at the section 63(2) of the Personal Protection Bill 2019, you will have the definition of an adjudicating officer. An adjudicating officer shall be a person of ability, integrity, and understanding, and must have specialized knowledge of, and not less than 7 years professional experience in the field of law, cyber and internet laws, information technology laws, policy, data protection, and related subjects. Now, having a look at Section 46 of the IT Act, for the purposes of adjudging under this chapter, whether if any person has committed a contravention of any provisions of this Act or any rule, regulation, the central government shall, subject to the provisions of subsection 3, appoint any officer not below the rank of the director to the Government of India or an equivalent officer of the state government to be an adjudicating officer for holding inquiry in a manner that is prescribed by the central government. And such problems could arise, and there could be claims for injury or damage that doesn't exceed 5 crores, provided that jurisdiction in respect of the claim for injury or damage exceeding 5 crores shall vest in the competent court. And there is this opportunity to give proper representation, and to make sure that after that person is satisfied of the contravention, he might impose such penalty or such compensation as he thinks fit in accordance with the provisions of that section. Now, under the Personal Data Protection Bill, there could be appeals to the appellate tribunal. There is an authority that is set up, that is proposed to be set up under the bill, and that authority, if ever it adjudicates in a particular manner, or there's anything that is there's any decision that is taken in relation to same, any person aggrieved by the decision of the authority may prefer an appeal to the appellate tribunal within a period of 30 days from the receipt of the order appealed against, in such form verified in such manner and be accompanied by such fee as may be prescribed, provided that the appellate tribunal may entertain any appeal after the expiry of the said period of 30 days if it is satisfied that is sufficient cause for not filing that within a week, within that period. Under GDPR, you have 2% or up to a sum of 10 million euros for some offenses. And under GDPR again, for data breaches that have not been reported, you have a sum of 4% or up to 20 million euros. These are for data breaches that have not been rectified. 4% of what? Or 2% of what? 2% or 4% of the global turnover of the company. So it is, if it is a group structure, if it has offices in 5 to 6 countries, 5 to 10 countries, the last year's turnover has to be lumped up and 4% of that has to be given. Now, more importantly, is you have to bear in mind that data protection, exchange of information between subject groups, groups between that have presence in Europe, that have presence in India, for example, that have presence in Mauritius, they need to have a standardized they need to have a standardized data protection policy. And what they need to have is they need to have an internal policy that should have the same or not, if not better protections than what is being offered by GDPR and the data protection. Under the Mauritian Data Protection Act, what you have you even have up to 5 years of prison if ever you disclose or you are seen to have taken part in a breach. What is more important is that a company cannot go to prison, so it is the directors that have to go to prison. And if the directors go to prison, this is you and anyone involved in that. It is for this simple reason that data protection is being taken very seriously today. Also, now looking at the Personal Data Protection Bill, when offense under this act has been committed by a company, every person who at the time of the offense was committed was in charge, was responsible to the company for the conduct of the business of the company, as well as the company shall be deemed to be guilty of the offense and shall be liable to be proceeded against and punished accordingly. This is in relation to specific offenses under the Personal Data Protection Bill, but the chance of imprisonment is here too. And nothing contained in this subsection shall render any such person liable to any punishment provided in this act if he proves that the offense was committed without his knowledge or that he had exercised all due diligence to prevent the commission of such an offense. Very difficult to prove. More importantly now, what we have to see is there is a financial sanction in Mauritius and GDPR, as well as as has been proposed by the Data Protection Bill 2019. What next? First of all, we have shown all the data that protects that you're surrounded with. Did you know that even if you had a CCTV camera that was taking pictures of your stuff or taking pictures of anyone coming in your office or anywhere near your office, you did not have proper safeguards, you were in trouble? Because a CCTV actually is something that actually records personal data of people. You see that person, you know how they look, and you're collecting personal data. You need to carry out an audit of your workplace. You need to carry out an audit of your company to see if you're complying with everything. You need to assess the risks. What are the risks involved in relation to a data breach and a data leakage? And you have to go for remedial issues. You have to make sure that you have taken the right measures to ensure that you are actually complying with the law. And you have to take important and you have to make sure that in fact what is happening is you're complying with the act. It's very important for you to comply. And if you're working with someone and that person is not doing all of that, you will still need to carry out an audit of your relationship with that person. You still have to assess the risk. You will have to take remedial measures, and you will have to ensure that they take important steps to ensure compliance. So it is not only you we are talking about, we're also talking about your partners and people you collaborate with. The other issue is equivalent jurisdiction dilemma. So if India, if any company from Europe wishes to send personal data, for example, a simple hotel booking or anyone booking a company, booking a car or booking anything in India, a travel agent or anyone wishing to transfer personal data or storing personal data in India, where they have their server, for them from Europe to be able to send that kind of personal data, India has to be given the context of the equivalent jurisdiction. They might not if the law is not passed, and this is where you will get issues, and this is where you have to make sure that you at least your company has got everything that it takes for you to make things happen. You have to check your contractual arrangement with everyone else to make sure that even they are compliant. And also, you have to check your own internal existing regime if they are sufficient or insufficient. If they're insufficient, you could be in trouble as well. Now let's go into more technical issues. These are the very technical issues which I've written myself a lot extensively and trained a lot about, is about taxation of the digital economy. For example, you will see the section 91.2, 91.1 of the personal data protection bill. What it talks about, it talks mostly about the special regulations being made for the taxation of the digital economy. For example, what is very important for you to be able to tax a service in a country is to be able to show the nexus as per the BEPS Action 1, Pillar 1. You have to have nexus, and you need to show that the money was generated in that particular country. For example, the common example that I use of that is most people use Facebook to promote their posts, or they use Netflix, they use Instagram to promote their posts. What they are going to do is they're going to pay Facebook to share data about themselves. For example, what they do, the company and all, and they pay, for example, $50 to share that page. They are in India. The target is in India. The service is going to be sold in India, but they are paying $50 to Facebook. How do you account for that in taxes? One of the suggestions that I made in one of the articles that I wrote uh, for uh, for one of the international journals is about the location for data protection. So which authority have you registered yourself under? Have you registered yourself under the Mauritian part, the Mauritian counterpart of the authority, or have you registered yourself in India? That is good enough to show nexus, which I've equated to be akin to a TRC, because under international law, any document emanating from an entity, be it a government entity, it should be counted. People should not look beyond that. So this is one of the suggestions. Now coming to blockchain and right to erasure personal data, as I've mentioned, you should be able to withdraw consent of the personal data that you've given. But anyone knowing how blockchain works your data is burned on a blockchain. Therefore, you will realize that blockchain actually was in its infancy when the GDPR was actually launched. Therefore, this provision has not been taken care of. Article 24 of GDPR mentions, for example, the fact that any automation, any processing of data that happens by way of automation, people should be notified of that, and they should be given the opportunity to go for iteration. This doesn't take place, and therefore your act as well, even if there's a blanket right that is being given under the act in the section 91, your act still has the opportunity to address that issue. And one of the issues with erasure is you cannot change what has been written on a blockchain. But what you could do, for example, is you could store the personal data outside. I'm working on it on a decentralized finance proposal for the time being, and this is our aim: is to make sure that all personal data is kept outside of the blockchain, and therefore the privacy policy takes care of that. And very importantly is the impact on automatic exchange of information. Now we'll tackle these issues shortly. What is also important is the fact that you have section 91 too, whereby we have till now we have been talking about personal data, but this bill also tackles non-personal data. And the problem with non-personal data is, for example, it includes trade secrets and trade data, which the authority can make you give. This is causing a lot of trouble, and this will cause a lot of trouble, and will kind of discourage people to go for that. Non-personal data could be any trade secret that the authority might ask for to see if the delivery of service is being well taken care of. Other important aspects are the impact on digital economy of the Personal Data Protection Bill. Section 91(1) mentions that the government has the full leeway to pass laws on that. I'm currently writing an article on the impact that a personal data protection bill is going to have on the taxation of the digital economy. Mauritius has already started implementing, and you have the equalization levy, but it might not be sufficient to capture quite a bit of the economy that goes along. So there should be more equalization. There is also anonymization of the personal data that is the subject matter. And what you have to realize is scope of non-personal data is going to include trademarks and IP, and this is going to go features as well for APIs. And if anyone is building an API, that collects data, that processes data, and you are asked for that, you might have to give up your algorithm. You might have to give up everything when you're requested for same by the authorities. How safe that would be for you to give up that information, that is up to you, and I leave that to your appreciation. And we have already discussed about the taxation of digital economy, about BEPS Section 1 principles, as well as the impact of transfer of data to Google API order and taxation of the data once received, which is going to show nexus and the BEPS Section 1 and mass transfer of data is also going to be subject to something called data privacy impact assessment. And that data privacy impact assessment under GDPR, be it under GDPR, be it under Mauritius Data Protection Act, or your personal data protection bill, that mass transfer has got to go through a data privacy impact assessment. And that data privacy impact assessment has to be done in collaboration with the authority. And when you're doing that, you have to register with the authority. And this is what is going to prove the nexus and give you the nexus. So this is, in my humble view, and I've written about it, that your registration with with the authority or with the supervising body should be good enough reason for anyone wishing the nexus to be proven and wishing to make sure that they use that to prove nexus as it comes along. And same for the source. And this is where everything will take from there. And most importantly, it is important to understand the reason why this bill is being ushered in. We have tried to brush a bit of the picture, and also it is also important to understand the impact of the decisions and to further understand the far-reaching impacts of such. Now I leave the floor to to my friends. Thank you very much for your attention. Any questions?
Hi. Hi, Arun. Can you hear me?
Yes, I can hear you. Go ahead.
Yeah, thanks. Thanks for the presentation. It was very exemplary presentation and it was so useful for all, I guess. Thank you so much. So before starting with the questions, I would like to add something over here that I couldn't add in the starting of the webinar because of my voice issues. So just a minute. Yeah. So just to bring some addition to the exemplary and so beautiful presentation by Mr. Arun. So I just want to add two things in it, that why this bill was brought forward by the government, like why there was a need arose for this bill to come into force. So basically in August 2017, the Supreme Court was the one who held that this privacy is a very fundamental right. And this fundamental right flows from the right to life and personal liberty, Article 21 of Constitution. And then the court observed that this privacy is very important to be preserved for each and every individual of our country. And the very most important aspect of this privacy is personal data, like personal data, which we are giving right from getting our clothes stitched from a tailor to opening of an account. We are giving our personal data to each and everyone nowadays. And what about the security, the protection of our personal data that we are flowing so easily to each and everyone? Like anyone can come to us and ask for our Aadhaar card, our KYC. There are so many payment gateways which are taking our KYC every now and then, and we are giving so crucial information of us. And what about the protection of that personal data? And also we are hearing news from them that every now and then, like MobiQuick, they have breached, Facebook, they have breached the data protection laws, they have breached our data security. So what about the protection of personal data of individuals? So that comes the role of this bill. Therefore, a committee of experts that was chaired by Shri Krishna, that was set up, which took so many issues relating to data protection in India. And this bill was drafted by them. And the Ministry of Information Technology and Electronics is the authority governing this bill. And they placed this bill, this personal data protection bill, in Lok Sabha on 11th December 2019, which was still on hold because of certain other things going with the members of council. So this is we are hoping this bill to enact in 2022, because in 2021, I don't think so, considering this pandemic at such a boom in India right now, it's going to be passed or even be placed in the session anywhere. So, and this bill is already being explained by Mr. Arun so beautifully in the presentation I held today. And coming forward, I would like to take questions if anyone have, or else I'll place my questions, which we have already noted before our presentation started.
I request to take the questions first. You start with your questions, we'll see.
Okay, I'm starting with my just. Just a minute. Yeah, so first question would be, what are the implications of cross-border transfers of information?
Well, most importantly, what you need to realize is that your act is very specific about two things. It's about exchange of information,
Mm-hmm.
where can it be processed, and where does it need to be stored or not. So, for example, your act is different as compared to the others because you define personal data, non-personal data, sensitive personal data, and critical personal data. So, non-personal data is something that is yet to be determined completely in all its completeness. So let's stick with personal data. Personal data would be anything that is personal. It could be transferred. It could be transferred to an equivalent jurisdiction and all. But when you have a look at sensitive personal data, it can be sent outside India, but a copy of that should be kept in India. This is sensitive personal data. This could be anything about your health, about your fingerprinting, and everything like that. And critical personal data cannot be processed outside of India. Therefore, there is this distinction. So these are the challenges, and we need to understand that before we understand anything else. So critical personal data is yet to be defined, and uh, this is how that personal data. These are the challenges that we will face when transferring personal data outside of India. And also importantly is, as I said, equivalent jurisdiction. You will have an issue. For example, if EU wants to send you information, if Mauritius wants to send you information, you have to be sure that you have that impact that is coming here. Does that answer your question?
Yeah, perfect. Next question would be, when a company shares data with third parties, how to make sure it's compliant by the company?
It's very difficult actually. It's very difficult, and therefore, what you have to do is before you enter any contract, or if you have any engagement already, you will start to have you will need to start asking for data privacy policies and all of your partner before you even exchange information with them. Because what could be happening is you could be acting in breach because you're sharing data with someone you shouldn't be sharing. So therefore, for compliance to be effective, what you need to do is you need to ask them for a certificate. You need to ask them for an audit report. You need to ask them for all the safeguards that they've taken and whether they comply with Personal Data Protection Act. Okay, there's no entity that is going to give you no governmental entity. At the very most, what they will do is they will give you a registration certificate with the supervising authority, but that's about it. So it is up to you to insist with your service providers, and maybe many of them will insist with you in order to be able, for you to be able to prove that you're compliant with that data. Make sure you bear one thing in mind though. At the same time, when this bill is going to be passed, when you're already late by at least 3 years, 4 years, so you won't have time. So might as well start now.
Okay. Okay, great. So this certificate would suffice our compliance.
This certificate will suffice for compliance, not the certificate from the authority, but a certificate where someone, an entity has assessed your system, has done an independent audit of your
Okay.
system, and has ensured that you actually comply with.
But
with the
Arun, there may
principle.
be cases, that concern company from whom we are sharing this data, that third party, they are not eligible. They are not like, you can say, they are not mandatory for them to get the audit done and get that certificate. So in that case, what to be done?
Any example? You're talking about small entities.
Like, yeah, I'm talking about small entities which, like, they have no idea what audit is that. Like, they are not compelled to do that.
Yeah, but then in that case, you take the risk, and ultimately it's all about the risk. This is all this act is all about. So, are you
If we enter
transferring
any
this risk?
or if we enter any agreement with them, like privacy agreement, or you can say confidentiality agreement, would that suffice in case
No,
in
that
that
wouldn't suffice
that would not
because
suffice?
This is one thing that you need to bear in mind, and this has been on with the GDPR, with all the consultancy that I've done for GDPR and all the consultancy that I've done for the Mauritius Data Protection Act. It's clear you cannot impose something on someone. It should be privacy by design and not by default. So you need to change the way you do business. You need to have a change in the manner in which you do business. For example, you will have to educate your people. Last month itself, we had a consultancy for the hotel industry. I think that was 2 months ago, where we were advising the company on data protection issues. For example, they were dealing with an entity that was not registered. So what happened is they had to assess their exposure, they had to assess their risk, and then get those people to put in the process and all. And that person was more than willing to do that bit about data protection and compliance and registration with the authority, for the simple reason that when they did that, what they were doing is they were getting their business, and therefore whatever is mandatory, there are very limited companies for whom that might, but even then a lot of it, there's only part of it that is not going to be mandatory. A lot of it is going to be mandatory for those entities, but it's only, for example, in EU, for small companies, they exempted from getting a full-time data protection officer and things like that. So for those small companies, for those small entities, which you need to make sure that you get them to do that, because you don't know where that could come. Because if they mess up or anything like that, you'll be in trouble, and you better have control over how they're making use of the personal data that you're sending, instead of just leaving it to fate or in their hands.
Okay, perfect. Thank you. That's an admissible answer. And my next question would be, what are the legal avenues available to general public if the data is misused by the data collector, or holder, like the data subject?
There's going to be tribunal. There's going to be a whole set of things that are going to come with the act. If the bill becomes an act. If I take the example of the Mauritian and the EU context, what is also important is in Mauritius and EU, what you do is you could write to the authority, supervising authority, and get them to report any such issues to them. And if ever an issue is reported and the person who registered with the supervising authority did not report the matter themselves as being a breach within 72 hours of that breach occurring, then they will be taken to task. So you have one avenue being the authority. Second avenue is, if you don't like your personal data being processed, what you do is you write to the company and ask for all the personal data that they hold on you, and within 1 month they have to reply. Or unless you have any other issues, they can ask for some more time before they give you your personal data, and then you can use your right you can actually then use your right to refusal before you make it happen, and then you right to erasure, and then you get them to remove your personal data from their system.
So this data protection authority, which has been established under this law, that would also help in this case?
Yes, this will help in this case.
Yeah, great. Okay, next is this. It's an interesting question that came in my mind, so I wrote it and framed it for you. So does recording a webinar like we have held right now, or calling while we're calling to our clients, or recording video in public that we make and post on social media, that also tantamount into data protection bill? And if yes, how to make sure it's compliance?
Well, it is a clear breach actually, because what is happening is you're giving data about someone. If it identifies that person, then that is. What you need to do is, when you're doing that webinars and you're recording, when you're starting the meeting, or even before that in your invitation, you just put Please note that when you register for this recording this whole session might be recorded and shared on social media, and you hereby give your consent to that. And you also mentioned that it might not be easy afterwards to erase that, because, for example, if you've shared the picture of someone and all, it might not be easy, and therefore you have to take care of that as well. So you have to have this disclaimer. It's easy because many people now, when many of my clients, when pictures are taken at an event, I make sure that they put a note on the invitation that your pictures might be taken and used for promotional purposes, and you're hereby giving your consent.
Okay.
And
And what if the cases where we are recording videos or taking pictures in public area, and we are clicking ours, but other public are also coming in those pictures. So what about that?
you should blank those pictures.
We should?
You should anonymize the faces of those persons who you don't know and or you didn't have the opportunity to ask for their consent before
Like we
processing the
can
data.
ask for consent from the public sitting around.
You can't, and this
Right.
is why. And the person didn't
This is what
consent
it
to
is.
be taken in the picture. The same thing happens when you share pictures and all, on
Yeah.
Facebook or social media. This is the
Yeah.
same problem that actually happens. So what is important is you could do that, and if they ask for erasure or all the data that you have, then you will have to erase. Or rather, don't even share this stuff.
Okay. Okay. So next question is, what is privacy by design and not by default?
Privacy by design is when, for example, what you do is you design a system of privacy. For example, you cannot just go and impose 5 volumes of privacy policies and expect all your stuff to go through it and overnight to comply with all those policies. Therefore, what you have to do is you have to have a build-up. You need to train your staff. You need to train your pew. You need to train your messenger that, listen, when you have a particular piece of information, don't just leave it lying around because it contains personal data in your office. You need to inform your security guy, but they can't just keep on looking at they can't just keep on looking at recordings of video cameras of CCTVs of all people and keep that recording for themselves. You need to be sure that you show which angle that is being recorded, and you don't collect information that is not relevant for your purposes. So these are things that you need to put in the system. You need to get a shredder. You need to make sure that attendance or any documents that you're keeping, everything is safe. Privacy is a culture, and you have to inculcate that culture well in advance. And you have to make sure that when the act comes, you don't find yourself in trouble. So this is privacy by design and not by default. In default is you just put a system, no one follows, no one is trained about, everyone just listens to that, and you haven't brought a change in culture at all.
Great. I agree. So the next question is, does mere exchange of business card enough to act as a consent?
Well, this is the nice question actually, because most of the times people think that once you've given them your business card, they can send you whatever they want. They can send you invites, send you anything, any newsletters, and every day you find yourself flooded with newsletters and all. This is not correct. And what giving away business card states is that this is who I am, and I'm sharing my data with you just in case you need me. Full stop. And if you want to send that person anything, for example, in newsletter, marketing material, and all, you need to contact that person and ask for their consent, whether they wish to still be a part of your mailing list, or they want to be part of your mailing list before you send them anything.
Exactly. I understand that this business card was shared with you only for a specific purpose, like for his business contact activities only, but no for any other activities.
Yes,
So here comes a specific consent, not a general consent.
yes. So
Right,
consent should be
right.
specific. Request for consent
And
should be specific.
perfect. Okay, so next question. Is it still a bill? So should we be concerned right now?
Of course. Of course, you should be concerned. In fact, we are present in India for the past, 2.5 to 3 years now, because I've been trying to explain people the impact of GDPR in India. And as you will see, I've done extensive work in relation to automatic transfer of information and digital economy. What is very important to note is it's good that this question came in relation for chartered accountants in relation to automatic transfer of information. There is a case between the US and EU, whereby it was stated that the privacy safeguards offered by the US Data Protection Act, something called Privacy Shield, that particular act, in fact, was not sufficient enough to safeguard data that was being transferred. You have around two to three. You have FATCA, you have CRS. Uh, these are information exchange, and you have TIAs as well. Uh, these are instruments for transfer of information, but these are not exempt from the rules of Data Protection Act and data protection policies. So if a foreign entity is sharing data, if your country is sharing data with a foreign entity, they still have to respect the Data Protection Act, and they cannot do that in outside of those principles. So what I suggest is for chartered accountants to start looking at this seriously. They could be protecting their clients from a lot of things, be it GDPR, be it through the Indian Act. And most importantly, you need to start getting ready for that. You need to start training your staff. You need to start getting the right habits, and you need to start getting things moving at that end. Don't wait for this bill to become an act. uh, you will have to comply at some point with GDPR. You like it or you don't like it. You will have to comply with Privacy Shield and many others. So yes, it's not. It's you're already late. India as a country is already late when it comes to personal data protection and all. So start now, because by the time it will take at least 4 or 5 years to implement in practice, and within 6 months or 1 year of it becoming a bill, you'll already be in trouble. So every year you will have to conduct audits, you will have to conduct trainings, you will have to conduct everything. So start now. As the
Rightly said,
saying,
Arun, rightly.
yeah,
Very right. We being professionals, we should act proactively and should take opportunity to take this as an opportunity of how we can serve to our clients, taking this bill and help them to compliance right from day one.
yeah.
Okay, another important questions and considering the current pandemic and what is the data privacy implications of COVID-19 and what advice would you give in that?
Well, I've written an article on that, which I think I should share. But most importantly is, people are not going out of their houses. People are using credit cards. You will have
Mm,
scammers. You will have people making use of the pandemic. So be very careful. You will have people calling you for phishing. You will have phishing calls. You will have people calling you for COVID testing and all these things, asking you random questions and all. So this is a very, very sensitive period. People are scared. They will give out just anything to stay in life. And when you're going out for treatment and all, be very careful as well, and make sure that you don't just give out personal information about yourself, uh, if any, and also make sure that what is how you're going to take that forward. So it's very important to take care of that. At the same time, just make sure that you follow the privacy policy of any hospitals and everything. It's a very dangerous situation right now. just be very careful with your personal data, with your business cards, your credit cards, and everything like that, especially online and when you get into. I have a question in relation to how from Mr. Krishna. Mr. Krishna sent me a personal message. How Data Protection Act will have an impact on WhatsApp policy change? Very interesting question. Well, in fact, if you have a look at the privacy policy of WhatsApp, they are actually sharing your personal data from one platform to the other, and therefore you should have the right and opportunity to be able to withdraw your consent and all. If you choose to use WhatsApp, you will have to abide by its policy. You cannot, well, in practice, you should be able. This is how the law is made as an impact. You should be able to choose which data to give and which not to. But in practice, it's very difficult to get that done and to get that sorted out. So the impact is going to be very clear in the sense that you should have your rights to ask for erasure of certain data, but most importantly, uh, your bill is actually going to cover any exchanges that you have. However, it is also important to note that WhatsApp has a very specific encryption model, whereby encryption takes place between two persons, and WhatsApp doesn't have any personal data from what it says, and I very much doubt it. So what I suggest is the Data Protection Act will have an impact on the WhatsApp policy change, but the decision is also yours as to what you choose to do, what you choose not to, whether you want to still use WhatsApp or not.
Okay, so last but not the least question on my side.
Yeah.
Please mute. Yeah, thank you. What impact do you find it on the working style of us as practicing professionals like company secretaries, chartered accountants, lawyers, and how and what precautions do we need to take to ensure compliance of this law while working with our clients?
You have to be very careful, as for example, as company secretaries, you have to be very careful with the names, with the board decisions and everything that you take, because these are all personal data. You have to get your board ready, because if they engage into any such act as company secretaries, you have to advise your directors. It's your duty to advise your directors in relation to any information. Also, when you're dealing with authorities, how much information and what information you give, that is very important as well. You should be very careful not to give out information about other parties. As company secretary, you also the legal advisor between inverted commas of the company and the board. And when you're advising the board, you have to apprise them of the risks that are involved, and you have to document those kind of risks. Now, as lawyers, you need to also check. We've done 6 years or 7 years ago. I did raise a point in one of my cases in relation to personal data. What information comes before your court if it has been obtained by way of a breach of data protection, of a breach of data privacy? The admissibility of that is very challengeable. It goes in the same vein of the fruit from the poisonous tree. So you have to bear that in mind when assessing that. And also, you could use that act to be able to prevent important materials from coming into the eyes or the purview of the courts. In relation to chartered accountants, I've just mentioned digital economy, very important. How you advise your clients, how you make sure that there's compliance, there's nexus and all, and at the same time, exchange of information, automatic exchange of information, which is going to go through a massive overhaul after the judgment of last year. And I'm sure there must be a case that will be coming from India as well in relation to exchange of information by the government to third parties under TIAs and TIAs, CRS, and FATCA.
Perfect. Thanks. those were the questions from my side. If anyone has to ask, please post your question in the question tab, or else
Sorry, Kirti, please carry on.
Mr. Mohta, else you can take forward and give vote of thanks to Mr. Arun.
Before giving vote of thanks, I have few questions. Like Mr. Arun, I just want to know, like, bill is already passed. So in India, so internationally, it's already been there, and it was really great presentation. I'm telling you, because it's a eye-opening session for me, I'll say. So next, I have just single thing. Any good thing which you should suggest for the practicing chartered accountant, as a I'll say, whosoever wanted to build their career in that particular field. So what is the right way to take it further, so that in time to come they will be recognized in a way, at least, or they can get a specialization in the specific law?
Well, for that, you need to talk to me in private. So this is a very vast question. So I think maybe I'll need to understand your aspirations first and then advise you accordingly. Because as you would see, I've been practicing that area for the past 12 years, and we're already talking about digital economy with blockchain, and its reach is very vast. Taxation of digital economy and all. So this is the proposition that I had made. I'm also the executive member of the IFA branch of Mauritius. I'm the technical chair, and in so doing, I made these proposals, and the Mauritian authorities are considering this issue of certification for the authorities, following my suggestions, and we'll have a meeting to discuss that aspect.
Okay, got it, sir. So, so somebody has requested me on the YouTube that can we get the PPT of the session? So,
yes, we'll try to we'll make sure. I think Medini is the person who is going to do the needful for the sharing, and
okay. Point well noted. I request Mr. Sachin to please give some word about the session, and then we'll definitely give the vote of thanks.
Oh, thank you, Himanshuji. It was really a great session. But before going this, I have a simple question. Arun, sometime what happened, whenever we sign up on the website, on any website, we have to put some information relating to the signer, like name, address, basic details like date of birth, name of spouse, address. So how far do you feel that these are a breach of data protection?
Well, any instance of anyone asking personal data from you, you need to ask yourself. For example, if I'm buying pizza, why do they need to know the name of my kids or my wife or the age of my wife? Unless this has got anything to do with appetite, I don't see any direct correlation with that. But this is to tell you that most of the times people ask for information that they shouldn't be asking. This is why a request for information should be very minimal. You only need that much information as you need. For example, let's take an example. If you're ordering pizza, they shouldn't be asking anything about your wife or children or anything like that. What they should actually be asking is your name, your address of delivery of the pizza, and what is the method that you're going to use to pay. Full stop. Anything more than that is asking for too much information. And any company that is asking for that kind of information, you need to be suspicious, and that company is going to get into trouble, because they are not asking for minimal information. They are asking for more information that they should be asking.
Okay, one more question. Being a professional, how we should preach before the client about this data protection bill? Because there are two things. One aspect we have discussed just now, that when the information is being asked from us, then what are the actions available to the signer? Number one. Number two, how to guide the client. Like suppose my client is going to open a website or doing any business. How can we guide them to what are the informations you should ask for from your customer?
Well, we are in the process of drafting privacy policies almost every week or every 2 weeks. Because if you give me a privacy policy, most of the times, you take an example. You have, I want to order something from Flipkart or any of the websites from Mauritius or US. What I'm doing is I'm inserting information over here and sharing it with you in India, for example. So you need to make sure that your website is compliant with the most stringent data protection policies, which is the GDPR. And therefore, what you have to do is you have to get it vetted by a proper professional who deals with all the aspects of that part of the business. So what are the rights, how are the rights safeguarded, and what are the rights that they need to inform. There's this, but you also need to make sure that you understand the whole concept and the whole business of that businessman, because the privacy policy should actually give you a glimpse of every single instance of data privacy, and it should be a window into your business and how the personal data of anyone is protected. So when you advise your client accordingly, as a professional, what you should tell them is if they don't take care and if they don't have the right safeguards and if they don't have a privacy policy and if they haven't trained their staff on who to call, how to process information, data and all, they could be in breach of the GDPR. They could be in breach of the data protection, personal data protection bill, and hopefully it becomes an act by the end of this year or next year. And subsequently, what is going to happen is they might even go to prison subsequently if they don't follow whatever is prescribed under the act. So this is how you will convince. I think if the doors of a jail doesn't sound very interesting, they will understand exactly what you mean.
Thank you so much, Arun. Before I invite Himanshu for formal vote of thanks, I'd like to personally thank Medini and Mahadev and Yogesh for being with us for the whole session. And I would personally like to thank Kirti because yesterday, as I come to know that yesterday she lost her grandfather, but she is today here. This shows her commitment level about the profession uh, and about this webinar. So thank you, Kirti, once again. And now I'd like to invite Himanshu ji for a formal vote of thanks. Thank you so much.
Yeah. So thank you very much, Kirti. Great dedication towards the session. And thank you very much, Mr. Mahadev and Mr. Madini, Madam Madini, for your continuous support. You guys were tremendous, I am telling you. And thank you very much on behalf of GCP. I, the chairman of chairman of the Committee of Law. Thanks, Mr. Arun, for the great deliberation today. And I also thanks to our president and the vice president, Mr. Sachin and Mr. Atal, for being there. And thank you, Kirti, for leading this session. Your questions actually solved a lot of queries of the people, I'm sure. Whosoever is not there, whosoever is on the YouTube, are going to take the benefit out of it. Thank you very much, sir. Thank you. And stay safe, stay happy.
Yeah.
Bye-bye.
Thank you so much. Thank you to all. Thank you, Arun.
Thank you again.